Thank you so much, Stephanie, and hello, everyone. My name is Anya Linalesker, and I'm the Managing Attorney for the American Bar Association Commission on Domestic and Sexual Violence. We're very happy to have all of you with us here today as we again bring the Alliance for Hope team to you to share their expertise on strangulation and its intersections with civil legal practice. This is our third webinar in our four-part series, and today's webinar will focus on trauma-informed interviewing, questions to include when you're speaking with your clients about strangulation, and techniques for building an effective case. If you missed the first two webinars in our series, do not fret. You may find them on the ABA website, and I will paste the link in the chat box now. And now I'll turn things over to Gail and the Alliance for Hope team. Again, please ask your questions. Carly and I will be moderating the chat box, holding your questions for the live Q&A, and also holding on to questions that need follow-up after the end of the webinar. Thanks so much, and go ahead, Gail.
Fantastic. Well, hello, everyone. I feel like we're a family now. This is the third webinar on non-fatal strangulation, and it's like so cool to be with you and be able to finally focus on everything I've learned with respect to strangulation from a criminal perspective and now apply it on the civil side. And I get to hang out with Alexandria and Margaret. So we plan to kind of get right to it. But I always like to start with gratitude, and I am extremely grateful for the ABA, Anya, willing to partner with us and the council hosting this for us and making it so easy. And of course, OVW. If it wasn't for OVW, we wouldn't have the chance to really see our dreams come true with respect to learning as much as we can about strangulation. Since many of you have already heard our bios, we're not going to reintroduce ourselves. But we would just like to acknowledge that I am here as a result of two teenagers who died under my watch when I was a prosecutor, and had the opportunity to understand more about civil practice when I was a director of the San Diego Family Justice Center, and really understood the needs of victims needing civil legal services. So it was in 2011 when we were able to launch our Training Institute on Strangulation Prevention, which is a program and project of Alliance for Hope. So you can learn more about our program and all the resources we have on our website, and also you can hang out with us on Facebook. We do 15 to 20 minutes every Wednesday morning just sharing quick information about non-fatal strangulation with a lot of different people who have become experts in this field. So we decided as we start this is each one of us wanted to just kind of like share one key point that we want you to get out of this particular webinar. And for me is a commitment and continue to learn. That would be my wish for the day, that we all continue to learn. And I will share more about that in a story involving one of my very first cases as a prosecutor that also had a profound impact on my practice. So I get to welcome Margaret. Margaret, hello.
Hello, and welcome everybody. We thank you for returning to the third version of our webinar. I hope that you, based on the information that you have learned, that you will listen to your client more carefully, listen very carefully to the client as they describe the events that they have experienced. Alexandria?
Margaret.
Okay, hello and welcome, and we appreciate that you've come back to listen to us. The only things that I really need to impart are that you need to ask questions, and we're going to be going over the questions that we think are important to ask. You ask and document, you observe your client and document, and then you follow up with calls, pictures, medical needs. You have a duty to know the signs and symptoms of strangulation.
Thank you, Alexandria. And since Anya covered some of the key points we're going to do today, I think we just go right to the poll question. Perfect. Okay, are we ready to close this one and go to the, oh, you already did. Look at, did you attend session 1 or 2? Perfect. And looks like our attendees have been mostly at the first and the second. We got some newcomers, so they'll catch up. Fantastic. And then we have one more. All right, I'm going to advance. There it is. We still like to know who you are. Wow, I just love the diversity. Ooh, and I see some people I know. Okay. Well, I think that should cover it. And we can jump in. Nice diverse group. A diverse group and a smart group. Okay. We go ahead and end the poll. Okay. Coming back to the presentation. All right, friends, we're going to get started. Most of you answered all of those questions correctly, of course, but what we wanted to do is share something that's not published. This is how I learned a lot more about your world in civil practice. So we ended up starting a restraining order clinic, and we started the restraining order clinic very much like all restraining order clinics are handled, but we wanted to understand what we didn't know. So we did a study, and we looked at all the cases we could for about 6 months in 2011. And what was happening at that time is that victims were coming to the San Diego Family Justice Center. We had civil legal services on site. We started the restraining order clinic, really focusing on helping victims to get their restraining orders filed. At that time, typically the situation was a victim came in, you fill out the restraining form, an application, it goes to the court, and generally most of the temporary restraining order applications were granted. Then I noticed something very interesting. Not many victims would show up at the permanent hearing, about 50% of them, and there was a lot of witness intimidation, there was a lot of trauma, there was a lot of fear, there was a lot of concern, and there was this rush to try to add all this evidence at the time of the hearing as opposed to doing it at the front end. So, and part of the study is to figure out, okay, what do we have? How can we build these cases at the time the victim seeks the restraining order so we can reduce the fear, the anxiety, and the trauma? We learned a couple of things, is that children were present during the incident at least 41% of the time, and you're going to see this long list of corroborating evidence. And what we were able to do at the San Diego Family Justice Center, which most jurisdictions you can't because you're not co-located, is that we were able to attach a police report to almost every single Family Justice Center petition for a restraining order. We also saw that we can get access to 911 tapes, prior restraining orders, some medical records, diaries, cards, letters, text messages, a lot of great information. So we said, okay, we know we've got it there, so how do we pull it all together? And in the restraining orders that we studied, as most of them were domestic violence, we had some child abuse, sexual assault, elder abuse, and teen violence. So that was the first study, and we said, okay, let's figure out a way how we can get all of this in advance. But what we discovered is that the strangulation component, there was very little there. So we thought, what can we learn from the criminal justice side of the house that we can apply to the civil side of the house? And this is where we can start integrating our experience and our effort and knowledge. So what we did is that we used the strangulation form that we were using to build criminal cases in the civil case. And after we did that, a lot of things happened. One, by doing more, we got more. In other words, everything went up by 25% almost overnight when we changed our policy and said from this day forward, we are going to build our case in advance so the victim doesn't get fearful, concerned, or afraid. And if there is a urgency because the victim is at high risk, we are going to lean on the police officers to help us with an emergency protection order to get that done, get that protection underway until we build the case. But I wanted to share this with you because this is something that's not published and not everybody gets to see this. But when we started to ask more questions and document, just like Alexandra said, lo and behold, we learned a lot more. We learned that the common method was manual strangulation, 2 hands, and generally they were approaching the victim from the front. When we asked the question, where did this occur, the victim said 33% of the time, the bedroom and on the bed. How long do you think it lasts, knowing that they were traumatized? Most of them in this study said about 30 seconds. To my surprise, I'm highlighting the things that even surprised me, was that they said suffocation was also involved. So I wanted to come back to that because we talked about strangulation. And when we talk about strangulation, I'm including both, the suffocation and strangulation, because under our definition of strangulation, you are blocking blood flow or airflow. We also thought it was really important to ask about pressure. And you can see here, most victims said significant pressure was applied. And what did you think was going to happen? The common answer was, I thought I was going to die. How did it stop? This surprised me because he was calming down. And I think we can have a whole discussion on that one. And did you call the police? 62% said yes. This was no surprise because we were co-located with the police, so the police would refer victims to the Family Justice Center. And what I was pleasantly surprised to see is that more victims with more training and education were actually getting more medical attention. In our first study, we discovered that it was only like 3% of the time victims were seeking medical attention. So it was also great to see that there was some improvement. And here's the other startling thing, is that when victims were at the Family Justice Center seeking a restraining order where the chief complaint was strangulation, 37% of them said they were still having difficulty breathing at that time, which does lend to the business case for having a partnership with forensic nurses and or a partnership with your hospital or clinic that hopefully might be nearby your office. So a couple of other things that we discovered too is that now we're able, by asking questions, we can find out more about the symptoms, more about trouble swallowing, more about loss of consciousness. And here's, to my shock, surprise, and horror, how many victims had said there was urination and or defecation. As a former prosecutor, this information never came out. As you all know, victims don't want to talk about something that is so embarrassing. And victims also said they couldn't remember, but that only corroborates the fact that there was loss of consciousness. And when we asked a little bit more about what they were feeling now, we started to realize the impact of health consequences to victims who were strangled, where they had headaches, and they were talking about having a seizure at that time. And you have to wonder, was it a seizure or did they have a mini stroke? But we had a lot of information, including difficulty walking. So you can also see here that even after the fact, they were experiencing some things that could be consistent with some of that internal injury. So that's just a quick overview of, oh my gosh, all that is there. We just need to kind of turn things around. The next thing that we decided we want to talk to you about before we jump into our favorite top 10 questions is, I learned this the hard way, trauma-informed interviewing. And if I were to start all over again, this is the first thing I would tell everybody to do. Take a class on trauma-informed interviewing, because I was trained to start at the beginning, put everything in chronological order, and you keep on going until you get to the end. Well, my experience working with domestic violence victims, whether on the criminal side or the civil side, is that their memory was all jumbled up. And there is a bias. When a victim's memory is all jumbled up, we think she is not credible, and therefore we're going to have our work cut out for us. But what I've also learned over my experience is to take things that I traditionally thought was a weakness in a case and try to turn it into a strength. So that might sound kind of weird, like how do you do that? Well, the way I discovered is somebody has to explain why this actually is cooperation. So to me now, when I got a jumbled memory, that is consistent with somebody who has experienced trauma, because memory and everything that was happening to them when they got attacked is naturally going to be jumbled up. And I'm going to share with you the best video, 8-minute video in the whole wide world that I've been able to find on trauma and the brain. This little video is brilliant because it explains exactly what happens when a victim is attacked. And there's this another favorite word that I like besides the hippocampus, and that's called the amygdala. And the amygdala is essentially that fear center, that alarm that triggers the brain to start to react to what is happening and taking all information in. But when you have that trigger alarm, that fire alarm into the panic mode, it's like taking a sheet of paper with all the things that are kind of relevant to this case, and you just like tear it up. They're all little pieces, because when that trauma is happening, those memories cannot file correctly. And what I finally figured out, a little like too late, is that you have to ask certain questions that will help release where those memories were recorded. And they're recorded, or misfiled, I should say, in different parts of the brain. And by asking certain questions like, what did you see, what did you hear, what did you feel, those questions are like keys, and it unlocks that part of the brain to release that information. And going back to my analogy of a sheet of paper with all the facts of the case that get torn up in little pieces, if I had enough time, I can put all those pieces back together again in chronological order, but I need time. And one thing that helped me understand that is when I was a prosecutor and working with police officers, I also learned that police officers got 3 sleep cycles before they were interviewed about a critical incident. And I go, oh my gosh, why do you get that and our victims do not? Obviously there's a reason why, because if we waited for a victim to have 3 sleep cycles, they probably wouldn't tell us what happened. But officers got that opportunity to give the brain some time to put all the pieces back together again so they can tell a story in chronological order. So this is a definition that we generally use about what is trauma, and it's going to be what our victims, our clients are experiencing, the domestic violence, the sexual assault, even witnessing trauma upon another. So this is a nice way of kind of looking how everything ends up working. You got that amygdala that's going to kick things off. It releases some stress hormones, and then it also has an impact on the hippocampus, which, as you might recall when we did the medical, is responsible for making memories and recording it. And then it also explains why things would be jumbled up. So as we have gotten better at this, what all the trauma-informed interviewing experts will say is how you initially have contact with a victim or your client to develop that relationship, that rapport first. And it makes absolutely a lot of sense. Who's going to just trust you immediately without having some sort of connection? And essentially there are 4 key elements: being interested, concerned, empathetic, and non-judgmental. Basic stuff that we all know. One day I finally figured it out by just moving these words around. What is at the heart of it? It's really being nice with somebody. Sitting down face to face, asking them about their name and calling them by the name that they prefer to be called, asking them about their lives. A lot of people love talking about their children or the animals, and just making sure that they are comfortable. And I remember getting this training at those days by advocates, and one advocate said, Gail, before you start your interview with victims, you should just, make sure that they have water and something to eat, and, maybe find out if they have any concern about parking. And at that time, I did not know all of this. And I go, well, it seems to me that they would come to a meeting with a prosecutor and they would have all those things ready. They would have come here with something to eat, and they wouldn't park someplace where they had to hurry up and rush. This is how naive and, well, I'll just leave it like that. So I go, okay, I'm going to try this. And the next victim I met after I was coached by our victim advocate, I said, how are you doing? And I found out her name was Maria. She happened to be pregnant at the time. I said, can I get you anything to eat or drink? And she said yes, which shocked me. I go, okay. I'll get you something to eat and drink. And I said, is there anything that you might be worried about or preoccupied, or something that might make you want to leave early? And she said parking. And I said, oh my gosh, how did this advocate know this? Of course, they know everything. So one of the things I realized through all of this training is that if victims get confused, just giving them permission and letting them know that that's okay. And I'll give you another example where I screwed up yet again. I was sitting down with a victim, getting ready for a trial. She was a cooperative victim, which is unusual in DV prosecutions many times. And I said, let's go through things together so you'll feel comfortable. I thought I had a little better training at this point. We'll go from the beginning and we'll put everything in order and go all the way to the end. Well, you can imagine it didn't take too long before all of a sudden she triggered, and I probably triggered her. And she kind of disappeared right in front of me. And I said, oh my gosh. I said, would you like a break? We've got some now snacks in the office. You can also take a little bit longer break if you want to get something to eat and maybe have lunch right now. We're getting very close to that. And she said, sure. She left, and I never saw her again. And that had always bothered me. Like, what did I do to trigger her, and can there be a better way to do that? So that was one of those lessons learned where I go, I got to keep learning and figuring out better ways to interview victims. And that's when you come back to, what did you see, what did you hear, what did you feel, what did you think, what did you taste, and what did you smell? And as I started to apply these questions to strangulation, as you will see, the responses just blew me away. So now we're going to go to those 10 basic favorite questions that we have to ask victims who are strangled after we have developed that rapport. Margaret?
Yes. The things that Gail just discussed are so very important in dealing with victims of strangulation, building that rapport, and creating that an environment where that makes it easier for them to talk to you about what they have experienced, because strangulation is vicious and brutal. So ask them, did anyone place any pressure around your neck by any means? What did they do? What did they use? Did they use a cord? Did they use a rope? Did they use anything else? So describe the pressure that was placed around the client's neck. Did they use one hand? Did they use both hands? Have they done this before? How many times has it happened to you? And as Gail said, where were you when it happened? Did he approach you from the front? Did he approach you from your rear? So be sure you ask those questions about the type of pressure that was applied to the neck. How did you feel? What was the impact did it have on you? Describe with particularity what the client tells you. Were they fuzzy? Was it dizzy? Did it make their head rush? Did they see stars? Did they see black and white? Very often you're going to hear, I couldn't breathe. So explore that. Did they pass out? Did they vomit? Did they have trouble swallowing? And particularly the physical consequences that they experienced later on. Was there a change in their voice? Did they have difficulty and soreness when they were swallowing? Clients had to describe the event as, I felt like my head was going to explode. I felt like a rush of blood to my head. And as Gail said, they may have defecated or urinated on themselves. They had to change their clothes. And be very mindful that people may be embarrassed to tell you that they urinated on themselves or they defecated on themselves. People may be embarrassed to tell you how many times they have been the victim of strangulation. Ask them if they recall if their children were in the house or if their children were present. The children started screaming or yelling or ringing for help. In the first session of our webinar, we explained that there are so many different kinds of civil remedies in which you can describe the event of strangulation. But as it relates to children, most especially the trauma the children have experienced in issues of custody and visitation. Ask them about how long the pressure was applied. Was it just brief, or was it prolonged? Was it repeated? Was it continuous? Did it escalate? How hard was it? And on a scale from 1 to 10, ask them to describe the pain that they felt. These series of acts, the frequency of the acts, the nature of the acts, the escalating level of the violence, ask them to describe whether or not there were multiple or separate assaults. Ask them what they saw. Describe the victim, the assailant. We have found out that people have said he looked like death, as if he wanted me to stop breathing, with big, red, evil eyes. He looked like he was crazy. His eyes were big, open, and he was wobbling back and forth. I saw the devil. I saw death. I knew he was going to kill me. Very often, victims of strangulation feel that they are facing death as they are being strangled. So have them describe that, and again, describe with particularity the experiences. So you, in your pleadings, paint a comprehensive and detailed picture to the court of what your client has experienced based on the questions that you ask them.
Okay. As Gail had mentioned, many people said that it happened in the bedroom. You need to ask, was it outside, was it inside, was it in the bathroom? And as Margaret said, and as we have been trying to say, you paint the picture, because the greatest testimony you're going to have is your victim. And that victim testifying and answering all these questions in testimony, it's going to be extremely powerful and extremely significant. And every question you ask is designed to elicit more information and evidence. What did he say? I'm going to kill you, you bitch. Die. No judge or cop is going to keep you safe. I'm going to do an OJ on you. I didn't mean to squeeze you so tight. I don't need a gun to kill you. I can get you to the brink of death by putting my hands around your neck and squeezing. You also want to know what he said before and after he strangled you. You wanted to know I would like to know what you said. I want to know whether he threatened actually to kill you, an exact word. Everything in quote is an exact word. You want to know what problems they have, breathing, swallowing, talking. You want to ask them, what did you think was going to happen? Has he strangled you before? What did you think? Did you think you were going to die? I was afraid he was going to kill me. I really thought I was going to join my mother who died a few weeks ago. It was getting worse. I was worried he wouldn't know how to stop. In which direction was he looking? What was your emotional state and your state of mind before, during, and after? And as Margaret had mentioned, the children can be the greatest witnesses. So you want to look for witnesses to the assault, or witnesses to the injuries. You want to know how it stopped. Did you leave? I escaped. I passed out. My kids began crying. The police came. The neighbor called the police. The neighbor tried to help. Bingo, you have witnesses. And again, as I asked, what did you say? But more important, I would also, or just as important, want to know, had you had any pre-existing conditions? Were you pregnant? Were there any recent surgeries? And if you called somebody, who was the first person you spoke to? And what is it that you said? Because each of the statements you met, as part of this, each of the statements you spoke to, as part of your evidence, those spontaneous statements could get in as hearsay exceptions. So you really need to know because what was said. You want to just ask them to describe any attempt they had to protect themselves. Did they try to push, bite, kick, scratch, pull the hair of their abuser? This is important because I could see the abuser saying, look what she did, she bit me. But those could be defensive wounds. So you really also need to establish who was the primary physical aggressor. And you want to know, was anybody wearing jewelry, rings, gloves, anything, watch. These are important. You may see marks. This is important. Additionally, I would want to know, how has this impacted you and how do you feel today? And if there was medical, if there's a criminal case, was there medical treatment administered? Because this is how you gather your evidence. One thing that Michaela from Ohio asked, and I think this is very important, and this is for Gail, is there data in how long victims of strangulation would have difficulty breathing, swallowing? Because that could be evidence you use for spousal support. That could be evidence you use if you bring a tort, a continuous tort. So Gail, could you answer that for Michaela and all of us? Hello?
Sorry, I had myself on mute.
Oh,
okay. Oh my gosh, I'm seeing all the questions too. Two things. I'll go ahead and answer that one, but I'm going to try to stay focused on getting through the material, so this way we have more time of Q&A at the end. But difficulty breathing and swallowing is a very good question, and it varies from person to person, as we all know. I believe that more victims seek medical attention is when they are having that difficulty breathing. We definitely recommend, and as you saw in some of our materials, is that victims need to pay very close attention to what's going to happen within 12, 24, 36, 72 hours, because things start to develop, get worse, they're swelling, and they need to seek medical attention. And generally, when victims are still feeling that discomfort in breathing and tightness, and they're not able to eat or drink, that's what drives them to the hospital. And that's when the strangulation assessment card becomes so important, because a lot of medical providers still have not received training in strangulation. So I will leave that question right now there, because it varies, but definitely I'd say pay attention to the next 72 hours. Next, what I wanted to kind of just summarize is we got excited. Did you see that with how many questions you can ask? So overall, the key principles will be understanding trauma, developing that rapport, starting wherever the victim is or your client, and using that what you remember. Start wherever you want to be. What did you see? What did you hear? To get the conversation going, then you listen and go into the very specific questions. We just gave you 10 basic questions, but there's more. I feel like the AT&T commercial, but wait, there's more. So if you go to our manual on the investigation and prosecution of strangulation cases, we have a whole chapter on what questions to ask. If you are a forensic nurse who has been trained in strangulation, they've got a ton of questions that they ask when it comes to a victim who's been strangled. And there's like a great tool, which we'll make sure to include, and that is a tool from the International Association of Forensic Nurses that a number of us got together to develop that toolkit for forensic nurses, and we got a lot of amazing forensic nurses right now who are hopefully chatting away with respect to that. So lots of other questions to ask, but you got to at least start somewhere, and we've covered that. So now what we want to do is shift, and we wanted to kind of like share our own personal experiences on the things that we have learned, the things that we have learned that we wish we knew then, and we would have done a much better job, but we get to at least share it with you now as we still continue to learn. So I wanted to share with you this point. Do the best that you can until you know better. Then when you know better, do better. That was such an inspiration to me, and it was a very important time when I read that quote from Maya. And I was starting to learn more about strangulation and starting to reflect on all the cases that I handled and realize there were many cases I mishandled, and it was starting to like just tear me apart. But what I want you to know, especially for those of you who are receiving this training for the very first time, thank you. Be good and kind to yourself, and now take all this information and you can do better. But my story was really about continue to learn, and the reason I made that promise to a victim many years ago was I switched from being a defense attorney to becoming a prosecutor. I'm now working with Casey Gwynn at the San Diego City Attorney's Office. He assigns me my first case to prosecute a case, and he said the victim has chosen not to be in court, so you need to prove this case without her. I go, I got it. We're going to do it through spontaneous statements. We've got a good 911 tape. We got good spontaneous statements to the officer. The officer was there. We've got some photographs, and this dude was a really bad dude. He had convictions for domestic violence involving other women, and when I looked at the photos in preparation for court that day, he not only had strangled her, but she was beaten to the pulp. And I have to admit, what I was focused on was the injuries that I could see. I did not understand the significance of choking. To me at that time, it was like he pulled her hair, he choked her, grabbed her arm, and I just focused on the pictures because everybody was kind of like trained to understand what they can see, and most people don't understand what they can't see, and so I blew it. But long story short, here's what happened at the case. I walked into that courtroom that day and had this bad feeling that something bad was going to happen. I think we all have them at some time or another. It's called uh-oh feelings. And instead of saying, Dale Strack, I'm ready to proceed, let's go to court, let's pick the courtroom, all of a sudden, out of nowhere, I said to myself, Your Honor, could you call to see if Maria is here? And the judge did. And all of a sudden, in this very busy courtroom where all the cases are being called in the presiding department, I hear this voice in the back of the courtroom, and she said, here. And I went, oh, I didn't think she was going to be here. And then I played a little voice in my head, which was Casey Gwynn, and he said, Gail, the victim's not going to show up, so you don't have to worry if she recants or how she testifies, so you don't have to worry about calling an expert witness on DV dynamics. We'll talk about DV dynamics next week. And I remember thinking to myself, maybe I should have had that class on DV dynamics now. But anyway, the case gets trailed. I go talk to her, and at first it starts off being really nice. She says, thank you, Ms. Strack, for pursuing this matter. This is in essence, but everything is fine now, and I would like you to dismiss this case. And I said, well, my name is Gail Strack, and I've been specially assigned to the Domestic Violence Unit, and we have a protocol where we believe that we need to hold people accountable because in domestic violence cases, this is going to happen again. I had a very basic conversation with her, and then to fast forward, she starts getting mad at me because she's now insisting. What I was listening and watching were like two different things. Her eyes were telling me one thing. The words that were coming out of her mouth were telling me another. The body language started to look desperate. It got to the point where she was like almost hysterical, trying to make sure that this case gets dropped. She even said that it was all her fault, that she started it first, that she was taking drugs and alcohol and hit him, and it was all in self-defense. And then I just kind of like had to take a deep breath, and I go, okay, because now I've got an obligation to share this information with the defense. And all I kept saying at that young age is, my name is Gail Strack. I'm here to help you. And I'm assigned to the domestic violence unit. I need to call my boss. I'll be right back. So I called Casey Gwynn in a panic because I'm thinking like, oh my gosh, we have this injustice happening right in front of me. And I go, Casey, we need to like drop the charges against him because she just told me it was all her fault and she hit him first. And in fact, you know, she actually called me a name and she was yelling at me. When I was a defense attorney, they were much nicer than they were to me than Maria, the victim. And so I was like, oh my gosh, you should have talked to me about DV dynamics before. And so all of a sudden he says, because I was in a panic trying to track him down through calling in a public telephone booth and trying to page him in those days, he calls me back and then he says, Gail, let's go through the facts. Let's go through the evidence. And we went through everything all over again. And then he says to me, I trust you will do the right thing. And I went, okay, because all of this is like, wow, this is not what I expected. So I go in and I said, Your Honor, we're ready to proceed. Let's go to court. We go to court. We start the trial. I go through the whole thing like we're going to prove it. Spontaneous statements, 911, photographed, everything is fine. She ends up testifying for the defendant, comes up with a completely new story. Now, fortunately, Casey Gwynn comes to the courtroom and sits right beside me because now I have to cross-examine her as their witness. And I just go like, oh my gosh, how do you do this? So I used the power control wheel, was very nice, so at least I didn't mess that up. And we complete the whole case, and then all of a sudden the jury comes back and it's guilty, to my shock and horror, because all of this was like a big surprise to me. But I followed what Casey had told me, and in my heart, I knew that he had assaulted her, and what she went through was horrific. So at this point now, I argue sentencing, and I said he has a long history. He's been doing this to other victims. I asked for the maximum sentence because you tried to send him to counseling before, and he never goes. So he goes off to jail. Click, click. Bailiff comes in, and he goes off to jail. And I go, oh, good. Now hopefully she's safe. And then all of a sudden, Maria is like behind me, and she goes, Ms. Strack, and I froze. I think it was my amygdala that just kicked in, my fear center, because I was like, oh my gosh, you know, she was really mad at me on Monday. This is now Friday. What is she going to tell me now? So at first, and I'll just be honest with you, at first I go, let me just stay still. Maybe she'll go away and she won't yell at me. But then she insisted, Ms. Strack, I'd like to talk to you. So finally I got the courage. I turned around and I looked at her. And I bet you all know what she said to me, and it blew me away. She said, thank you. And I go, thank you. She said, yes. And I go, can we sit down and talk, because it surprised me. And as we sat down and talked, she said, I'm thanking you for not dismissing the case. And she said, do you remember on Monday morning when the case got called and you called out my name and then you walked towards me? And I go, yes, you were in the back of the room. She says, do you remember as you were walking towards me, I bet you thought he had his arm around me. I go, yes, I actually thought you guys were hugging each other. And he goes, well, that's what he wanted you to think. But he had his hand on my neck. And every step you took, he kept squeezing harder and harder and harder. And I was crying. I was hysterical now, because I'm going like, oh my gosh, here I am, a prosecutor, trying to dedicate myself to helping victims of domestic violence, and how could this be happening right in the courtroom? So as we kept talking, she really was my instructor on DV dynamics. She went through the power and control wheel with me and explained everything. And she was thankful that now he was going to be in jail and she could try to put her life together. And then she was talking about getting a restraining order. I said, we can do that. And she talked about her children and everything else. We must have sat there and just talked for a good 2 hours. And at the end of that conversation, I'm going to try not to cry. Right? I made a promise to continue to learn. Because if we're going to work with these cases, I needed to understand everything that they're going through and do the best and be confident at this. So that's why I put this in. Do the best that you can until you know better. And when you know better, we get to do better. So I'm going to turn it over now to, I think it's Margaret who's going to share her story next. But in this process is we can be so much better and so much stronger by learning from each other, integrating all the things that we've learned from different systems, from criminal system to civil system, and also fighting for victims in both ways. So I'm actually going to go back to this and ask Margaret to jump in.
All right. Like Gail, before I started working here at the Family Justice Center, I've been practicing law for a long time and consider myself a really good domestic lawyer. However, I had had no training in trauma-informed interviewing. I've noticed that people who come through our Family Justice Center who have been briefly abused over a long period of time, there's a sadness about them. A lady came in, she was pregnant, and it appeared that she was trying to camouflage her pregnancy, and she wanted a legal consultation about custody of her unborn child. So I went over that with her. She was sad. She was withdrawn. She was spoken a very quiet voice. And like we said earlier, both Alexandra, Gail, and me, you have to be gentle with people because they are, some of them are living in absolutely horrific conditions. And she was very concerned because the man was threatening to take her unborn child. So I had interviewed her about an hour before she ever mentioned that she had been strangled. And I remember questioning her about it and how quiet she was. And I remember how, when I asked her if it had happened before, she said yes. Well, fortunately here in our Family Justice Center, we have a high-risk team that is headed by Sonia, who's on this webinar, our Client Services Coordinator. And we have 13 criteria about high-risk clients. And so one is strangulation. So I made a referral to the high-risk team, that is to Ms. Desai. And when we make these referrals to her, we usually have a high-risk meeting within 24 hours because she will get together all the representatives of all the partners here in the Family Justice Center that the client has seen. Because sometimes the client will tell the advocates one thing and they won't tell the lawyers, or they'll tell the lawyers and they won't tell the advocates. We are very careful about confidentiality and explaining to the client the legal ramifications of sharing their information. But we had a high-risk team, I believe, meeting the next day to address the safety of this particular lady and her unborn child because we were very, very, very frightened for her. I remember this so distinctly because she did not take out a complaint for a domestic violence protective order. But I also remember the diligence of the partners here at the Family Justice Center in following up with her, even weeks later, just to see if she was safe. So as I've been saying repeatedly throughout the webinar, listen to your client. They may not tell you right away. They may be embarrassed to tell you. They may be afraid to tell you, but I also have found that in telling a client, regardless of what they do, that it takes courage to come to the Family Justice Center or to go wherever they may go to seek help. For those of you who are listening who may not have a Family Justice Center in your community, but wherever that client goes to seek help, I always tell them that it takes courage. And I find when you tell them that, you see a glimmer of hope in their eyes. Tell them that they have a right to live without brutality. They have a right to live in peace, and so do their children. So again, I would strongly encourage you, listen very, very carefully to what your clients are saying. Watch their demeanor. Listen to what they are not saying, especially the older experienced attorneys who know when there are gaps in stories when your clients are talking to you, but listen very carefully to the clients because everybody's not going to always tell you, everybody's not going to always have visible signs that they've been strangled. Alexandria?
Thank you. I want to preface mine with before strangulation and my understanding of it, which is not all that long ago. I always saw strangulation as a symptom of the larger issue of domestic violence. What I have learned as I've moved through many of Gail's trainings is that not all domestic violence is the same, that strangulation is the most lethal form of domestic violence, and had the need to separate strangulation from domestic violence before you bring it back together. So I don't have just one story, but I will say that several years ago, a client came in. I thought, I would argue I'm trauma-informed. I interview her. She was very, very quiet, very soft-spoken. And as she talked, I noticed that she was hoarse, but I ignored that. After a little bit of time, she became extremely agitated and said that she would like to come back. So she left, and probably a week later, she called me and wanted to come back. I noticed she was hoarse again, so I said, would you like to, now you have a cold. Would you like a cough drop or something? And it took her an hour there just going through some of the domestic violence before she stopped, and she informed me that she was hoarse because her husband had repeatedly choked her. And as we talked, and I didn't want to go into the fact that this is not choking, this is strangulation, because I didn't know that then. And she said, she kept using the word attempted. And now I know that she never really saw what he did was problematic. She saw that as attempted, meaning that he may have put his arms around her neck, but if it had been real strangulation, she would have been dead. So I will never forget that. I am so cocky. Oh, yeah, would you like a cough drop for your cold? I was concerned she had it when she came back. But I never suggested medical. I never suggested this has been a week, maybe you need to see somebody. So I have learned so much. And I would say that as civil lawyers, now that you know what you didn't know, your job is to be that conduit to the court, to law enforcement, to medical personnel, to advocates, to explain everything you have learned. And most importantly, what evidence exists that you never used before, and read your law. I'm not just talking about your statutory law, because we don't even have a statute in Ohio. I'm talking about your case law, and I know we'll talk about that later. So that is the story I wanted to share. I had signs. You need to pick up on them. Thank you. Gail?
Sorry, I muted myself. Thank you. So now what we want to do is shift gears and give you plenty of resources under the umbrella of think like an investigator, build that case. We thought it actually would be helpful to share with you a free online training for first responders. I'm seeing some questions about police. I'm also aware that we have police officers here, so thank you. But this is an online 30-minute course for free that was developed by the Pennsylvania State Troopers Association and the Pennsylvania Coalition. We worked with them to put this together under the only condition is please give us a link, let us make it available to everyone for free. So initially we were saying to all the police, because this is not mandatory training for all police officers, it's only if you got really cool people on this webinar right now who are taking the time to do it, will they educate themselves. So then we started to challenge police chiefs across America to do this, order everybody to take it. And then it turned out that this was actually a good program for every agency to take to get your entire office at legal aid on board on talking about the same language. So that's a tool for you. Goes over some really basic tips on investigation. I mentioned this before, but we've got a strangulation manual on how to do this better. We have two, and the one from California is going to be updated and released. Actually, it's already been updated. I'm just waiting for it to be released. But I like the Alaska manual, and I saw someone from Alaska. The Alaska manual actually added 3 new chapters, one about children who are strangled. And as you can imagine, if mom is strangled, the kids are at risk of being strangled too. You can only imagine that if grandma is in the house, elders are at risk. And they also did a really nice chapter on community-based advocacy. So I wanted to share that with you. Documentation, you've heard us say, is extremely important. So now I wanted to share some of the tools that we created that would be very helpful to you, and we're actually now doing another one. So initially we created a specialized form for domestic violence to document spontaneous statements, that history of domestic violence, gathering the photo, what evidence was impounded, did they seek medical treatments, did paramedics arrive, because they take great information, what about the use of drugs and or alcohol, because if it's not written down, things have a way of coming up later. Then we also wanted to focus on the children. Were the children there? Were they exposed to this? What was their demeanor? A lot of this is gathered for a lot of different reasons, but we also have the body chart. So if there was no visible injury, we have now been trained by the medical community that you do have to consider head-to-toe injuries and literally ask victims, where does it hurt? So the form was developed to document just pain and where that pain occurred, because we know that visible injuries will appear days later. We also wanted to know about prior restraining orders. We've heard this a number of times. Victims will seek a restraining order, drop it, come back and seek another one. Well, all of that is evidence that you can use, and then asking a victim for a medical release or dental release to get that information. Then the evolution happened. Well, that was great for domestic violence, but we needed a specific one for strangulation, and this is our very first one. And it's still being used, but a couple of things have evolved. I met this amazing sheriff officer, and he took one of these classes, and we're always encouraging people to be creative, make it better, do it better, and then send it back. So Alex Smith did. And he said, Gail, I think what's missing out of this form is your method. He goes, I'm a self-defense instructor. I teach everybody at the sheriff's department all of the ways that we, control the suspect, how you could defend yourself. And I said, what are you talking about? And then he shared this with me, which I just love. I go, it's so clever. I go, Alex, this is trauma-informed, and you don't even know it. Because if you are traumatized in the middle of all this, and someone asks you specifically, how were you strangled? How was pressure applied? It may be hard to get all of that out. But his idea was just to have the victim point to the actual method that was used and how many times was it reapplied. I think it was absolutely brilliant. So I'm constantly bragging about him. We have a new one, and this one is still being discussed by a whole team of a legal committee of police officers and others that are taking a look at it. But I would say use one of these forms for your own practice in building your restraining order application and or your case. So what we wanted to do now is give you those resources and then shift gears to go deeper into practical. So what we decided to do is have both Alexandria and Margaret share what's happening in their particular state and what we can learn from case law. So, Alexandria?
Thank you. All right. Ohio has what I think is one of the most comprehensive bail statutes. And in the statute, when we were looking at adopting it, it includes all of Jacqueline Campbell's major risk factors. And it said if you've been convicted of domestic violence, violating a protection order subject to a temporary criminal protection order, you are required to appear for bail hearing. But the most important piece is, to the extent that this information is available to the court shall consider the following. So we began to train probation officers, pre-sentence investigations, prosecutors, so they would know about it. We've had some issues, but sometimes this information can get to the court. Now, of course, this is in the criminal context, but that moves into some of the cases that we've looked at in the civil context. And the most important one I want to go over is actually SEE versus SCE. You'll see it on your screen a little later. I'm going out of line. But in this case, this was a case where he had choked her. He had appealed his conviction for a civil protection order saying that he wasn't a danger to her. Among the incidents causing her to seek it was his grabbing her by the throat, carrying her by the throat, and then throwing her and discarding her on the couch. So he appeals that, but the precipitating incident that caused her to walk in on the day she went in to get the protection order was when he squeezed her neck for several seconds in the presence of the child. Later that same night, while in bed, he leaned over and pinched her nostrils closed, causing her to open her mouth because she couldn't breathe. He denied choking her, and he said, there's no evidence, there's no change in her demeanor, and she went back to bed with him. So, therefore, couldn't be anything that she was worried about, could not have been choking. Now, in the testimony that was used before the trial court, they used a guide that the Ohio Supreme Court put together called Domestic Violence and Allocation of Parental Rights and Responsibilities Court Guide. We do not have a judicial bench card. We do not have the lethality factors printed yet for all courts. So our bench guide did. It had lethality factors, it had how they apply to the best interest factors, and then what type of parenting plans to use based on what you see. So they talked about strangulation, coercive control, all the things that she raised in her testimony. And then the Court of Appeals came back and said that in testimony, she argued that the guide, that his behaviors are known indicators and risk factors for DV. The guide ID strangulation, controlling behaviors, and abuse during pregnancy as high risk for serious physical harm. The court relied on that guide when it granted her protection order. The Court of Appeals, after he appealed, said one more thing. Her appearance of happiness when she went back and slept with him in bed does not mean that no choking occurred. She was much more credible. Now, I know when we look at how to address these lethality factors, well, how else can we deal with that? And one other way is a Kentucky case called Pettingill versus Pettingill, in which the wife obtained a protection order. And in findings, the court made use of the variety of lethality factors. He argued that the court on appeal should not have taken judicial notice of these lethality factors. And then it went up to the Supreme Court, and this is the most important piece. We know that a trial court in most states may take judicial notice of adjudicative facts like the weather, things that are not subject to dispute. But the lethality factors are not facts, but risk factors used by courts, law enforcement, counselors, and social scientists to evaluate the threat of future domestic violence. And the Supreme Court of Kentucky differentiated between judicial notice and judicial knowledge, and said that the way the court was informed about these lethality factors was considered judicial knowledge. I've not used this in a case in Ohio, but I recommend finding that case and utilizing the information that it provides. Now, going back to the other cases, the reason I have these cases out there, first State versus Smith, because I use these cases to see, well, listen, we have 12 appellate districts. How do these appellate districts view these cases? How do they view strangulation? In Smith, the treating emergency room physician testified he observed petechiae on the upper portion of the victim's face, and that her injuries were consistent with extreme choking pressure that was a life-threatening act. Therefore, it is hard to fathom, the court said, that choking a victim to the brink of unconsciousness does not amount to a substantial risk of death. Now, in this case, there was sufficient evidence. Another one, State versus Wagaman. Victim testified he grabbed her by the neck, choked her till she was unconscious, and he said he didn't choke her, and his claim was supported by the absence of marks on her neck. However, in this case, they brought in a SANE nurse who testified that the absence of marks after choking is not unusual. A loss of consciousness due to choking would support a finding of serious physical harm. A loss of consciousness, irrespective of how long, satisfies the definition of temporary substantial incapacity. So with the forensic nurse's testimony, the victim's testimony, the use of photographs, the court, based on all that, affirmed the trial court. Then we have State versus Plot. In that case, the SANE nurse testified not for this particular victim or her case, but just generally on the identification, the effects of strangulation, and that her injuries were consistent with a strangulation injury. This is important. If you not, additionally with Plot, it said the SANE nurse testified as to her expertise. She was a forensic nurse. She was trained as a sexual assault nurse examiner. She had over 50 trainings on domestic violence and strangulation. So what we see from a case like this is you don't have to have that expert testify for a particular case, but just testify about strangulation generally. And you don't need it's always good if you had Dr. Smock, but you don't need the expert. You only need somebody who knows more than the ordinary person. And we have the Supreme Court case that speaks to that. And in this case, the testimony of Ruth Downing regarding the effects and identification of strangulation was reliable to be admissible as expert testimony, and that was affirmed by the appellate court. Additionally, now this is a sad one, State versus Ryan. He was convicted of felonious assault, DV, and kidnapping, sentenced to 3 years, appealed that there was no evidence. He had beaten and strangled her 3 times to the point of unconsciousness. She urinated. He also tried to throw her out of a car, and he threatened to kill her. So she goes to 3 different hospitals before they found somebody who could identify and address the trauma to her throat. It was at the 3rd hospital where there was a forensic nurse who examined her and then testified in court. This nurse had recently received strangulation training and spoke to the fact that you need to look for these internal injuries, that strangulation is extremely serious. And the court then determined that her testimony was very credible. The only other thing, and I will end, is that when I went looking for every case Ohio has on strangulation over the last probably, 100 years, what we found is that experts can testify about a specific person. They can be a nurse, a medical examiner, a doctor. They can talk about unconsciousness. They can talk about near-fatal strangulation. Sometimes they can just give opinion on the injuries are consistent. Sometimes victims have gone to hospitals, have had these CAT scans. Most of the time, no. What we've also learned is that you can be a deputy coroner, you can be a police officer to testify, you can be a 911 operator. And when you're looking at testimony, did the victim say anything to that 911 operator? In one case, the victim was out of breath, and the 911 operator noted that in the log. So my point is, you can always look at your case law to help determine what the appellate districts think about strangulation, how much they know about strangulation, and what is needed for expertise in the area of strangulation. Thank you.
Well, thank you, Alexandria. Thank you so much. I will also just add one point. As I'm looking at the law across the United States, what's really kind of cool now is that they're not even contesting the testimony of forensic nurses as experts. So in that last case, there definitely was no objection to her testimony. So that's cool. We've come a long way. First, it was hand-to-hand combat. And I remember in Ruth Downing's case, I think she was on a Daubert hearing for days before she could even get to testifying. So progress is made by that gentle, relentless pressure. So Margaret, tell us about your law.
All right. Well, fortunately here in North Carolina, our General Assembly has passed a law that addresses strangulation specifically, and it is a Class H felony. That law was passed in 2004 and specifically states that the person who assaults another person and inflicts serious bodily injury is guilty of a Class H felony. It goes on to define serious bodily injury, creates a substantial risk of death or that causes serious permanent disfigurement, coma, a permanent or protracted condition that causes extreme pain, or permanent or protracted loss or impairment of the function of any bodily member or organ, or results in prolonged hospitalization. And subsection B specifically says, unless the conduct is covered under some other provision of law providing greater punishment, any person who assaults another person and inflicts physical injury by strangulation is guilty of a Class H felony. So a body of law at our appellate courts has developed since that time. I'm not going to discuss every case that is in the PowerPoint, but I do want to discuss 5 of them in particular. The first being State versus Braxton, which came down in 2007, where the defendant on his motion to dismiss challenged what the state had to prove in order to carry its burden of proof. And the Court of Appeals ruled that the state was not required to prove that the victim had the complete inability to breathe in order to prove the elements of assault by strangulation as per the statute. The defendant contended that the definition of strangulation should be interpreted according to definitions found in dictionaries, which require proof of a complete closure of one's airway, causing an inability to breathe. But the Court of Appeals said no. They said, were they to accept the defendant's definition of strangulation, the state would be required to show that a defendant strangled his or her victim to the point of death or close to it in order to prove assault by strangulation. So the court said that the state did not have to prove a complete inability to breathe in order to carry its burden of proof. But aside from that ruling on strangulation, as we have mentioned to you, there is very often a lot of witness intimidation in strangulation. And in this particular case, the defendant specifically encouraged the victim to dismiss the charges against him, to not show up in court, to write an affidavit to the district attorney saying that she made everything up and that the charges were false. He specifically instructed her as to the content of what to include in the affidavit, telling her that it must state that he did not choke her and that he never intimidated her. On one day, he called her 10 times, asking her not to testify. So the evidence of his efforts to recant were addressed another legal issue in this case. I'm only bringing it up to show you the list that people will go to sometimes to try to get victims to recant. She actually did prepare the affidavit, but when it came to trial, she testified. But this, the court in this case also says the strong and harsh language that the defendant used against the victim, coupled with the evidence of volatile and violent relationship that they had, constituted sufficient evidence such that a reasonable mind could find the message to be threatening. So in your civil complaint, discuss the strong and harsh language that the defendant has used and they outline the volatility of the relationship and how violent it has been. The second case I wanted to talk to you about is State versus Little. And most of these cases are where the defendant is on appeal is challenging the sufficiency of the evidence as to whether or not the state has carried its burden of proof. And the court goes on to define strangulation, not specifically, define it on a case-by-case basis. There is no statutory definition of strangulation in the statute, but the court has decided that you have to look at the facts of the particular case, and the determination of whether or not the state has met its burden of proof is based on an analysis of the facts, even though the term is not defined in the statute. And when you think about it, what other logical conclusion could they come to? Because these cases are fact-based. And in this particular case, the court concluded, even though strangulation was not defined in the statute, when the defendant wrapped his hands around the victim's throat and applied pressure until she lost consciousness, that fell within the boundaries of the term of strangulation. The victim also testified that she feared for her life, which was ample evidence of the assault, the court said. She also received cuts and bruises on her neck as a result of being strangled. And those cuts and bruises were confirmed by photographic evidence. So based on the totality of the circumstances and what happened in this case, the Court of Appeals concluded that the state had presented sufficient evidence of each essential element of assault by strangulation, and the trial court did not commit an error. So therefore, the court is going to look at the facts in the particular case and try to determine whether or not the burden of proof has been met. And I would argue to you that you allege those facts in your pleadings, as we've continuously said. The next case that I want to discuss with you is State versus Lancaster, where a child was egregiously abused over a period of time by his mother's boyfriend. And he argued that the method that he used did not amount to strangulation, the method of the assault. But the court, and he challenged the sufficiency of the evidence with regard to assault by strangulation and argued that strangulation required a closing of the windpipe through the direct application of force to the throat. The evidence in this case showed that the defendant pulled the child's head back by one hand while his nose and mouth were covered by the other hand, making it difficult for him to breathe. The statute says that you have to show that the person has been assaulted and assaulted by strangulation. The Court of Appeals ruled that the statute does not require a particular method of restricting the airways in the throat. In this particular case, the defendant constricted this child's airways by grabbing him under the chin, pulling his head back, covering his nose and mouth, and hyperextending his neck. Although there was no evidence that the defendant restricted the child's breathing by direct application of force to the trachea, he managed to accomplish the same effect by hyperextending the child's neck and throat. The fact that the defendant restricted the child's airway through the application of force to the top of his neck and to his head rather than to his trachea was immaterial. So there's no particular method that has to be used in order to meet the statutory criteria for assault by strangulation. Also in this case, there have been multiple separate assaults. So in your civil pleadings, outline the different events that have occurred to the victim so that the court can see the brutality and the viciousness that they have experienced. The next case I wanted to discuss with you is State versus Gwynn, where the defendant contended that error was made when the jury instruction on the definition of strangulation that he had tendered to the court was not applied. And the court ruled that the trial courts following the pattern jury instructions on the definition of strangulation was sufficient because the pattern jury instructions state that strangulation is defined as a form of asphyxia characterized by closure of the blood vessels and or air passages of the neck as a result of external pressure on the neck brought about by hanging, ligature, or manual assertion. So the court rejected the defendant's assertion that the term strangulation has to be a specific legal meaning on which the jury must be instructed. That case also relied on Braxton, which I have already discussed with you, and the court declined to adopt a rigid definition of the term, and again stated you have to look at the facts of each case to determine whether there was sufficient evidence of strangulation. The case of North Carolina versus Gwynn, a recent case in 2018, reaffirmed the Little and the Braxton case, and the court ruled that loss of consciousness is not necessary to prove strangulation. The court has found sufficient evidence of assault by strangulation in a variety of circumstances, and so therefore a victim does not have to lose consciousness in order for the state to carry its burden of proof that the person has been strangled. So there's one common theme among these appellate cases in the state of North Carolina, and that is a careful analysis of the facts. What happened to your client, the series of acts, the frequency of acts, the nature of the act, the escalating level of the violence, the multiple assaults, the viciousness, the brutality, the excessive force, the physical and emotional effect that the client has suffered. So again, describe with particularity in the civil pleadings each distinct act of violence that the client has suffered. And again, paint a comprehensive and detailed picture to the court of what the client has experienced. Gail?
All right, thank you. So what we wanted to do now is more resources, more information to help you do a better job. But before I jump into that, I want to point out a couple of things. As we've been collecting these cases from all across the United States, what wins these cases is solid investigation. So for those police officers that are on this call, the fact that you are on this call tells me a lot about you and that you're continuing to learn. But your investigation and asking these questions has been significant. Because I've also seen cases, which is rare, that have been reversed on appeal because of a lack of sufficiency of evidence. I mean, think about that. That's almost like impossible. But what would happen in the underlying case, there was really no good investigation about the questions. There was no use of an expert. And the Court of Appeals said this isn't enough for felony strangulation. So that was a key point that I am finding in all of this. We are now collecting civil cases as well, and they're starting to come in, which is really beautiful. The most recent one was from Delaware, where the court understood strangulation and gave the victim a full, well, no, it's kind of like lifetime restraining order. And the civil court was using criminal cases to beef up her reasoning to give a lifetime restraining order. So knowing the laws we said before will help you build these cases. So what I want to do now is building these cases, and I want to tell you what's going to be in your Dropbox. In your Dropbox, you're going to find my very first trial brief on a civil restraining order case when I was at the San Diego Family Justice Center. As I mentioned before, in my spare time, I teach law school to recruit the next generation of domestic violence prosecutors, defense attorneys, or civil attorneys. So I was working with the law student, and what you're going to see is I kept it the same, the very first one, where we did a couple of things. We put together a trial brief that included the witness list, the exhibit list, and the exhibit list included the police report, the medical records, photos that we took at the Family Justice Center, also an affidavit from a police detective working at the domestic violence unit at the Family Justice Center. She had never testified before as an expert in strangulation in a criminal case, and we thought, heck, why don't we get Sylvia Vella to testify in the restraining order case? Great opportunity to start practicing her abilities and testifying what she has learned to educate the judge, and filed a motion with an affidavit to convince the court that she should testify. That motion was granted. Filed another motion within the trial brief to get judicial notice of all the articles. That motion was denied. But as we said before, sometimes you have to lose to win, because after that, judges were ruling differently on these restraining order cases, because just like what we learned on the criminal side of the house, the same arguments and defenses that come up in criminal cases come up in civil cases. In other words, she has very little injury, therefore she was strangled. She has no injury, therefore she was not strangled. She did not seek medical attention, so therefore she was not strangled. The same arguments come up, and now you have the benefit of all this case law where it's already been ruled, and you've got to make good use of it. Now, at the end of the day, it did turn out to be a credibility issue, and the court did not issue her the restraining order, which was heartbreaking. However, the good thing that came out of it, because many of the folks from the Family Justice Center, the police officer, the detective, the advocate, the civil attorney, and the law student, they were there to support her. And even though we lost, she felt believed, and she felt supported by the team that was around her. And that was a really important turning point for me, and the realization that it's those little things that matter, and victims need to be believed, even if you may not win the case. So the next thing we wanted to share with you is just a couple of more tips, wrapping this up, and then we're going to open up to questions Now, Alexandria, I noticed that you already talked about this great case from Kentucky. I don't know if you wanted to add anything else. If not, we will go to Margaret.
Yes, I just wanted to, since I did go out of turn, I wanted to just mention that many of you may have adopted or enacted or had by constitutional amendment Marcy's Law. And I think you could look at Marcy's Law and it may be effective. In that, Marcy's Law says that in our constitutional amendment that there should be reasonable protection from the accused for the victim. And if that is the case, you can utilize bail factors to move that forward. And what I mean by that is that in the event they let somebody out an OR or personal recognizance and they don't keep them in and then that person goes back and hurts them, that could be a failure of that reasonable protection of victims' rights. You can probably ask that they stay in jail pending the pendency of the case based on the same argument that a victim is entitled to reasonable protection. So when you look at that, I think that Marcy's Law can be something you consider. And I think I will stop. Thank you.
Thank you. So Margaret, what's your last tip before we open it up for panel questions?
All right, just one thing I forgot to add. North Carolina, although it's not as strong as Ohio, does have a bail statute in GS 15A 534.1 that addresses, that covers strangulation and domestic violence for you North Carolina people that are on our webinar. But I would encourage you to be creative in your legal thinking. Be creative in your thinking, in your civil pleadings, as you seek to protect your clients and ensure victim accountability. Sometimes civil attorneys don't always think to use various rules of civil procedure to address certain things. Is an injunction available? All kinds of things that you can try to seek for your client, but be creative in your pleadings and think outside the box as you try to use civil remedies to address the needs of your client, to get them to a place of safety, especially for them and their children, and to ensure the offender accountability. So I would just say be creative in your legal thinking.
Gail, can I just make one other comment? And that is, you had mentioned creating that trial brief. One thing that I think is also important, if the judge won't let that information in, they deny it up front, you should always, if you are going to trial in any case, that's it, a custody case, a spousal support case, a tort case, a civil protection order case, ask to make a written closing argument. This way you can present all that evidence in your written closing argument. Any affidavits, any studies, any other points that you want to make regarding strangulation, the lethality factors. So you don't always need it in your case in chief. You can do it as part of your closing argument.
Perfect. I like that idea. So, oops, I went too fast. To summarize, and I've seen it in the chat room, we've got more, just like I said, but wait, there's more. We will make sure you have access to our manuals, specialized reporting forms, the trial brief, the sample affidavit for a detective. And I see, Dale, you're on here. I don't know if you've tried this already, but this is really a gift, because a lot of times just reading your affidavit will result in a negotiation and you can skip the whole trial. I will be adding a sentencing brief. I did not talk about that, but it's essentially probably the equivalent of a written closing argument. We also have a bail motion, and we have a motion to introduce expert testimony. And we're happy to share that. Next time we all get together, we're going to be talking about advocating for your client, So news at 11, but right now we are finally ready to bring Anya back and ask Anya to summarize some of the questions. There's one that I did see related to more training. I love that one. More training on trauma. I will tell you that our friends at EVAWI, End Violence Against Women, they've got a great library and a lot of wonderful webinars specifically for police officers on how to interview. But as I said before, we can learn from each other, from each discipline, whether they're initially geared to civil attorneys, police officers, or prosecutors, or even the defense attorneys. There's great information out there. The key is to continue to learn. So Anya, what themes have emerged?
Sure. So you touched on one of them. Tanya and Dale and perhaps others who are law enforcement officers and professionals were looking for specific training beyond IACP, the International Association of Chiefs of Police. And so if there are other ones either through your organization, you mentioned EVAWI, to raise, that'd be great. I would just note that for civil legal attorneys, that is something that we train on at the ABA Commission. And so we'd be happy to work with you on that in your organization. But I don't know if you wanted to add any more to that question that's specifically from the law enforcement perspective.
I think that's it. And you can Google know it. It's amazing what you can find online. David Lezak is a great instructor. Dr. Campbell, another one, Russell Strand, a lot of amazing people. Just keep listening because it takes a while to get it into your DNA and into your bloodstream, and then you just start spitting it out. And it's just kind of been fun to see the aha moments from folks who have taken that training and have seen the results.
A sort of parallel question related to that comes from a participant who's asking about what you do as a civil attorney when the responding officers did not interact with your client, with a survivor, in a trauma-informed way. And so what do you do with that to discredit their lack of proficiency on the stand when perhaps their response at the time that they came to the scene did not help your client or help your client's case?
I'm sure we all have our perspective, but for me, I mean, that's going to be normal. Not everybody is going to be a skilled interviewer. And at the beginning, when we started to figure out how to do a better investigation and interview with strangulation victims, I would just say we just did it over and we did it right. So maybe the patrol officer didn't get it right, but the domestic violence detective or sexual assault detective can get it right, or you as a civil attorney can get it right by asking these questions. And then later you're going to have to explain, which is normal, why was the information provided to person number 2 better than the information provided to person number 1, and you can certainly explain it. I mean, for the patrol officer, all it would take is a few more questions. Officer, have you been trained in domestic violence? Probably yes. It's usually required at the academy. Have you had any specific training on non-fatal strangulation and what questions to ask? No, it's not in my protocol. It's not at the academy. Have you had any training on trauma-informed and understanding the impact of trauma to the brain? No, I have not. And that's all you really need. And then you go on to the next interview or next witness and you start building that case and explaining why that victim may not have shared that information with the initial patrol officer who responded, but got a lot more information from Detective Dale Nix because he is trauma-informed and knows how to ask questions and got a lot more information. So that's the way I would play it. I don't know about Alexandria or Margaret.
I agree.
As do I.
Okay, then we're ready for the next question.
Great. So the next question is looking at the intersections of a concurrent criminal and civil case, and in that, raising any concerns that you may have as faculty around jeopardizing a criminal case when you're preparing for a civil interview and your civil case, and how you address that.
Gail, I'd like to start with that. In in Ohio, we have both civil and criminal protection orders. The criminal orders are part of the criminal case. The civil are standalone orders. You can have both at the same time. However, the criminal protection order that is part of the criminal case is no longer effective when somebody gets a civil protection order. And even if they're denied their civil protection order, that criminal order is no longer effective. I would not bring a civil protection order case while the criminal case is pending. It is used for discovery. That defense lawyer can come in and get all kinds of discovery that he couldn't get under the criminal rules. Additionally, he could use any evidence he has to impeach the victim by just getting a transcript. And I think it does more harm than it helps for the criminal case. So I would wait until sentencing before I would do a civil protection order. Now, I say that generally. I think on a case-by-case basis, if we know that that perpetrator is going to be in jail, has no money for an attorney, I may feel very differently. I would also feel differently if the victim needs to get custody of her kids or needs money soon that we can't find another way to do it. But a general rule is I don't mix those cases. Gail, Margaret?
Well,
So with
I
Margaret.
come from a different perspective because when in the criminal case is the DA's job, my job is to protect the people from being injured, further injured or killed. And so therefore, I think that you may put a client in further danger if the civil domestic violence protective order is available to them and it is not utilized. So far, I haven't had any problems in domestic violence orders negatively impacting on criminal cases here in Guilford County, but I'm not a district attorney. I'm a civil attorney, and our domestic violence protective law order is a civil remedy. My main concern is, in my position here, is the safety of our clients, and so therefore we are going to advise them and we are going to strongly encourage that they seek a domestic violence protective order if they have been injured or placed in fear of imminent serious bodily harm or meet any other of the other statutory criteria for the issuance of a domestic violence protective order here in the state of North Carolina.
Okay. And now Gail. So I am kind of agreeing with everybody, and I just want to bring up some different considerations. So in a perfect world, you would have everybody talking to everyone. But what happens in a lot of jurisdictions, the civil side is siloed from the criminal side, and sometimes you have conflicting orders. The biggest challenge that I've seen is that you have a criminal stay-away order, but you have children. Just like Alexandra said, you need custody. You want to have certain visitation or no visitation, and the criminal court is not going to take care of that. The other thing is I've seen victims without protection if the prosecutor dismisses the case, because the minute that case is dismissed, so is that criminal protection order, and then she is left without any protection. And nowadays, civil restraining orders can do a lot more than a criminal stay-away order can with respect to even kick-out orders, making sure bank accounts aren't wiped out, and the list goes on. I would say if people are aware of two proceedings happening at the same time, what I have seen is criminal defense attorneys will try to continue the civil case, so there's nothing that can be used against the defendant in the criminal case. So just like Alexandra said, she would be thoughtful about what information goes into the civil case so it can't be used against the victim. The same is going to be true for the defendant. However, if people let the client speak and you got that civil restraining order finding from the court saying, I've heard both sides of the stories, I find the victim more credible than the defendant, and you or respondent pose a credible threat to the victim and she deserves protection, that is really powerful evidence for a prosecutor to know that she already has that finding in another court. And in some jurisdictions, there's even findings of domestic violence which you can use in different settings. So lots to think about, and I think overall it's going to be case by case. It's going to depend on your law. It's going to depend on how well one system works with another, and then ultimately what does your victim need. Okay. We've got 15 more minutes. Anya,
yes, no, thank you.
Questions?
Absolutely, and out of what you just discussed, the next question is related to use of this information in context outside of the criminal justice system and even outside of what some people call restraining orders or civil protection orders or orders of protection, and that's how strangulation has been used in custody cases or perhaps even in divorce cases. Is that something that you've seen in your practice, and how has it been received by the courts?
Start with Alexandra and Margaret, and then I can share what I'm seeing in case law or what's coming up.
In my practice, I have seen strangulation as so far nothing special. If we move the court on understanding domestic violence, I think we've gotten somewhere. If we can then move the court on the lethality factors, I think we have movement and we can go somewhere. Therefore, speaking about strangulation is probably the most lethal lethality factor. Is going to go a long way on educating the court. We're waiting to see if we have a law that we're supposed to have passed hopefully by the end of November or December. If that happens, everybody's going to learn about strangulation because it's in our statute. Until then, all we do is we keep offering these trainings, we keep talking to people about them, and we utilize, and we have the ability to utilize now the Ohio Supreme Court's court guide, as well as, I think, specifically, you can utilize what we learned out of Pettingill. We can use these things, maybe if there's a strangulation case, bringing in an expert to talk about that. And then, hopefully, we're going to get these courts having a better understanding of strangulation and its place as part of the lethality factor list.
Margaret, anything you want to add?
Yes, based on my experience, I haven't seen it used extensively in civil court, but it can be, particularly under the North Carolina Divorce in Bed and Board statute, which is the legal separation statute, is an indignity. And one of the grounds for divorce in bed and board in North Carolina is domestic violence. It specifically states the statute number 50B. So as I've been saying, plead with particularity and in detail what happened to your client. Strangulation is an understatement. The strangulation is an indignity. It is an understatement that strangulation is a condition that makes your life burdensome and intolerable, which is some of the civil statutory language in North Carolina for the grounds for legal separation. And it's clear as a crystal to me that if a child witnesses a parent being strangled, thrown on the bed, force applied to the point that the person passes out, may defecate on themselves, urinate on themselves, the impact it's going to have not only on the victim that's being strangled, but on the child who witnesses it. If that doesn't go to what's in the best interest of the child, I don't know what does. If that doesn't go to the what's in the best, which is the statutory criteria for the award of custody, the initial determination of custody in the state of North Carolina, and also I think it's applicable if it has happened after a custody order is entered, because the statute said there's been a substantial change of circumstances since the entry of the last order that justifies a modification. So as I've been saying all along, plead with specificity. If a child has witnessed with strangulation, that needs to be brought up in an initial custody determination. That needs to be brought up in a modification issue. That needs to be brought up on an issue of visitation, particularly unsupervised visitation when the person hasn't done anything to rectify the conduct that that child has witnessed. So there are so many parts of this, the body of information about the devastating consequences of strangulation that are applicable in so many civil remedies. If a person has lost their job because they were injured and they had to stay out of work as a result of strangulation, that's an economic injury. The medical bills, all kinds of things that people can experience as a result of strangulation. So as I said initially, look at the physical effect, but also look at the economic impact. But look at the psychological impact too, especially children who have been victims of trauma. They very often need to be in counseling. It affects their relationship and their trust issues. It affects sometimes how they perform in school. Look at all these things to argue what's in the best interest of the child as far as initial determinations and or modifications of custody regarding children. Be creative in your pleading.
And incorporate the use of these risk assessments in your practice so you have the ability to articulate these lethality factors.
All right. So I'll jump in now and share what I'm seeing on a national level. Most of the case law is on the criminal side, and it's being used there. On the civil side, not so much. I literally have found maybe 5 cases, 10 at the most. What I am seeing is CPS cases where if a parent strangles a child, you're probably going to lose your child custody there. If a parent chokes his wife, and mostly, as we said before, this is a gender crime, they also are at risk of losing custody of their child. If a child sees mom being strangled, that I've seen one case said yes, that is an impact to the child, just beautifully how Margaret described. In another case, the court reversed and wanted more information. So here's what happened. Dad strangles mom. Mom is holding the baby. I think the baby was like 4 months old. And initially, there was a finding that this is in the best interest of the child is in danger. It got reversed on appeal because they said there was no evidence as to how was that baby endangered. I think we could all disagree here, but specifically in the record, there was no testimony or no evidence to show how the baby was in fact injured. So that was one. The only other one that I saw had to do with another strangulation case where the victim had been strangled. He gets convicted on felony strangulation and he goes to jail. She is now pulling herself back together, doing actually quite well, gets a business license to start taking care of children. As she's getting her license, I can't remember the agency that was providing this, found out about that conviction. And they said, look, we're going to give you this license. We want to help and support you. Kids need care. But if you let him back into the house, you're going to lose your license. So he gets out of prison, and guess what? He wiggles his way back into the house. The agency finds out, and they revoke her business license to run a child care facility. And that's where I've seen it as well. So it's starting to show up on the civil side, and that's why we wanted to be here today, to kind of bring more awareness and education on how we can learn from what has already happened and integrate it into the civil side and educate more people.
Thank you all. I think that's exactly right. There's a role for civil attorneys to educate the court about the serious lethality associated with strangulation, even though, in quotes, a traditional weapon isn't involved, and how that should be factored into best interest of the child in custody or in divorce cases, which you all highlighted on. So I think that's exactly right on. I will now say I think we should transition to wrapping up this session because we will have a 4th session in a few weeks, and now we can tell you how to reach us and get more information between the 2 final sessions.
So Anya, I'm going to need you to advance the slides because I'm getting that little colorful wheel that's going around and around and
No
around.
problem at all.
Okay.
So now I
I'm
have
stuck.
the slide on how to reach you, Gail.
Okay, well, there you go. You're actually, I think, even getting my cell phone number. So I'd say email me or text me. We'll get you whatever you need.
Margaret, would you like to summarize how people can reach out to you?
Well, yes, you can reach me at the Elon University School of Law. My email is there. My my telephone number, we will put on the next slide in the next webinar. I can just give the number out now if you want me to.
If you want, we could type it into the chat box for you.
All right, 336-641-6626 is my number where I can be reached.
Thank you, Margaret. I'll continue advancing the slides. And Alexandria, if you don't mind sharing information about how people can reach out to you.
I am, like I said, I work at the Legal Aid Society of Cleveland, and I will give you my telephone number as well, and I welcome any calls you have, and that my number is 216-861-5713.
Thank you very much to you as well. And again, a thank you to OVW. Gail, I know you like to do the slide, but I just stole it from you. I hope you forgive me.
Of course. I need your help because I can't advance anything right now.
No problem. And I'll just move on to the slide now about how we at the American Bar Association Commission can assist you. We traditionally work in the civil legal arena as a technical assistance provider, although our overall work crosses into every area of law. You can reach out to us if you are an attorney for technical assistance, which just means help. We can help you with research. We can help you with referrals to other peer technical assistance providers such as the Alliance for Hope and many others. We have office hours where you can meet one-on-one with a staff attorney to go through the list of issues and concerns you need support on. We have a number of trainings. I'm sure many of you have been involved in those, from hosting other experts such as this series to our custody litigation series, which we are transitioning now in the period of COVID to be an online training, as well as our trial skills, litigation skills training. We also have other areas that we can support you on in terms of accessibility of your services, whether it's disability-based, language access, or otherwise. And we have free publications for grantees on our website, as well as statutory summary charts. In the very beginning of this training, one of the participants noted that restraining order is not a term that resonates for them, and their jurisdiction has a very different meaning. We actually have a statutory summary chart that summarizes access to the civil legal protective order or documentation that some people call a CPO, an order of protection or restraining order. That was just updated, and so we'll be posting that and announcing it on our listservs as well. There is a question now from Eugene who wants me to move on, so I will. Yes, our Part 4 is coming up for you, and it will take place in a few weeks, actually on the 27th. So our fourth part of this series will take place on August 27th, and that will focus on advocating for your client. So again, thank you to Gail, Alexandria, and Margaret for their expertise, and for Carly also at the Alliance for Hope. Thank you to Sylvie and Jane at the Commission, and also thank you to Stephanie, as well as Daniel at NCJ-FCJ for helping us with this program today. And again, reach out to us for help. We're not ending our support for you now. We're here for you always. Thanks so much.
Hi, friends.
Bye, everybody.
Bye.
Thank you.